the criminal justice system. Some of what I'm going to talk through, I recognize could probably be an hour or 2 hour talk in and of itself. So I'm going to do relatively broad strokes, and then I want to talk through some of the questions you may have, concerns you may have, things that aren't clear to you, and do whatever I can to sort of help you understand some of the process. So let me just pull up the screen.
And for those of you that are just joining now, this is Deputy Chief Shawn McMahon. Thank you so much. And thank you, Eric, for organizing this, and Scott Stickwick on Chelsea News. Chelsea Community News.
I apologize. This is it's a good thing. I haven't actually Zoomed. We've been doing some in-person meetings, so my Zoom and screen sharing fluency is a little bit less than what it might be, but I think we are ready. Yeah. All right. Just by way of background, I guess I'll tell you who I am connected to the office. Again, my name is Shawn McMahon. I've been in the office it'll be 15 years on September 4th. I started in a trial bureau handling all manners of lower level street crimes, kind of moving up the ranks as my experience sort of built. I've handled, been in the domestic violence unit, the identity theft unit, I've been a sex crimes assistant, homicide assistant, handled narcotics cases, drug cases, violent cases, homicides. Became a supervisor in 2019. In 2021, by the end of 2020, became chief of the crime strategies unit. And many of you may have known Michelle Bayer, who was the deputy chief of the trial division. She left the office a couple of weeks ago, and I'm taking over her role and leaving CSU in very, very good hands. That remain to be seen at the moment. So I know I have big shoes to fill if any of you knew Michelle, but I will do my best. All right, so really the path that one takes through the criminal justice system depends on the way you're accused of violating New York state law. And in the criminal context, there are really 3 ways that you can do that. The ways that you can do that are characterized just statutorily by what the most serious penalty is. And then there are baskets of crimes that fall in each of those. Violation or an offense is typically the lowest level way that you can violate criminal laws in New York State. They are characterized by any offense that is at most punishable by 15 days in jail. Meaning the statute says the absolute greatest punishment you can get is 15 days in jail. If somebody who is convicted of a violation or offense is not a crime. So conceivably you could be convicted of a violation and you would not be a quote unquote criminal, and you would not have a quote unquote criminal record. They're relatively low level offenses. Some of the more common ones are disorderly conduct, somebody making noise or blocking the sidewalk or doing something largely, disruptive or unlawful to other people's ability to use public spaces or to go to and from certain places, certain public places. Another is a simple trespass. If you were to walk into a construction site with no other aggravating factors, you don't have any weapons, you're not intending to commit a crime there, you're essentially in a place that you're not supposed to be, that would be a violation trespass. Violations and offenses are typically the lowest level ways that you can violate New York state law in a criminal sense. Misdemeanors are the great majority of circumstances that the DA's office interacts with. We have a lot of felonies and there's a decent amount of violations, but the bulk, the volume, the majority of the volume of work that we do is in misdemeanors, just because they're more voluminous, not necessarily more serious. A misdemeanor offense is defined by any offense, or presently defined as any offense for which that can be punished by 364 days in jail. And I'll draw a distinction here between jail and prison in the sense that a prison sentence or going to prison generally means a state facility and generally requires one sentence to be greater than 1 year. So for misdemeanor offenses, the maximum sentence is a jail sentence, which in any county in the state would mean time in a county jail or a city jail. In New York City, our county and city jail for all of the boroughs, which are each counties, is Rikers Island. Typical misdemeanor offenses are, stealing without any other aggravating factors relative to the value of the theft. A grand larceny in the fourth degree is defined as stealing more than $1,000. So petty larceny is just taking without any aggravating factor with respect to the amount taken or the manner in which you take. The manner in which you take can be an aggravating factor in the sense that if you take from somebody's person, best example of this is a pickpocket. You reach into somebody's pocket or somebody's purse and take something while they're holding it or while it's on their person. The law characterizes that as a grand larceny in the fourth degree. Another is extortion. If you obtain property that you're not entitled to by ways of extortion, the law characterizes that method of stealing, extortion, as sort of an aggravating factor. So traditional shoplifting, if you go into a deli and steal a candy bar, that is a petty larceny, which is a common misdemeanor. Another one of the more common misdemeanors is assault in the third degree, which is a simple assault. Has really two elements: that the actor intends to cause physical injury, some amount of identifiable injury to a person, and actually causes that injury to a person. Most basically, punching somebody in the face and causing some pain and maybe some bruising, but not any real broken bones or significant injury. That's an assault of third degree, and it's a common misdemeanor. Felonies are the most serious ways that somebody can violate New York state law, and they're characterized by crimes that can be punishable by more than 1 year in state prison. There are different classes of felonies in New York State, from Class E felonies to Class A2 felonies. E's being the lowest. For example, the example I gave of stealing over $1,000, or stealing by method of pickpocket, taking something from somebody's person, that's an E felony grand larceny in the fourth degree. If you steal $1 million, that's a grand larceny in the second degree, which is a Class B felony. Within the felony classes, there are also violent and non-violent felonies. So grand larceny in the second degree is a Class B felony. Robbery in the first degree, which would be taking something by force with some aggravating factor, a couple of different aggravating factors. The most common might be displaying a deadly, insurance, or dangerous weapon, like a knife or a gun. That is a B violent felony. And the law in New York State distinguishes in terms of punishment between violent felonies and non-violent felonies. Namely, violent felonies, somebody who is convicted of a violent felony is exposed to more potential prison time. Now, all of these ways in which you can violate, and some common felonies are robbery. Robbery is when you take something from somebody from a person by force. Or burglary. Burglary is where you go to a place you're not allowed to be and take something from. When we're picking juries, we often have jurors say, "Yeah, I was robbed, or my apartment was robbed at some point when I was living there. I wasn't home. Somebody broke in and stole something from it." The law characterizes that as a burglary, when you go someplace that you're not allowed to be with the intent to commit some crime therein. That's usually stealing. That's the most common circumstance of burglary. Again, robbery is a common felony, taking something by force, whether it's by threatening somebody, by fighting with them to get their purse. A purse snatch can be a robbery. There are different degrees of robbery, and the felonies or common felonies escalate through sex crimes and the most serious crimes that the penal law recognizes. Shooting somebody, stabbing somebody, attempting to kill somebody, and murder in the first and second degree. Now, I've characterized, and the law characterizes these by what their most serious penalty is. But beneath that most serious penalty, there are often many options. So the consequence to a violation might be, time served, literally the time you were in custody. And actually, for a lot of crimes, whether they're misdemeanors, felonies, or violations, the consequence can be time served. Only the amount of time, or you're punished to the amount of time that you were in custody following your arrest. There can be community service. There can be programming options, probation, You can, on a felony, you can do a certain amount of jail time instead of prison time. There's really a lot of flexibility in terms of consequence within each of the categories of violation, misdemeanor, and felony. None of which, absent certain circumstances, most of which don't require somebody to go to jail. There are certain circumstances that felonies do, most commonly related to the seriousness of a violent felony, or a person having previously committed or previously been convicted of a felony in the past. So violations, again, are not crimes. They're punishable by a fine or 15 days in jail. Misdemeanors are, in fact, crimes punishable by up to 365 days in jail. And felonies are characterized by crimes that have a potential punishment of more than 1 year in prison. Now, most people's entry into the criminal justice system, whether it's violation, misdemeanor, or felony, happens with an arrest. And there are two kinds of arrests. I'll start the second one. I'll take these out of order. An online or a live arrest is what, law and order, all of our common understandings of an arrest might be. That's where I walk into a store, I steal some property, I run outside, a police officer, somebody shouts to a police officer, he apprehends me right there and puts handcuffs on me and takes me to the precinct, fingerprints me, and that night I go to the criminal court building downtown, or in some circumstances, I know a number of you have questions about Midtown Community Court or potentially to Midtown Community Court, and I see a judge, and the process begins there. Desk appearance ticket is slightly different in the sense that the first part of that interaction is mostly the same. Somebody commits a crime, a police officer has reason to believe they've done that, probable cause to believe they've done that. They arrest them, take them back to the precinct, confirm their identity, and have the option in certain circumstances of giving that person a desk appearance ticket. It's called a desk appearance ticket because they're given it at the desk in the geographic police precinct, and the ticket says you have to appear on this date in the future. It's generally about 20 days from the arrest, and the person who's given a desk appearance ticket has to appear, again, occasionally in Midtown Court, but the greater volume of desk appearance tickets in Manhattan require someone to appear downtown at 100 Center Street. There are certain, and this is a little bit fluid, it most recently changed in May 9th of this year. The rules governing when DATs, what crimes are DAT eligible and under what circumstances the police department should issue DATs changed most dramatically at the beginning of 2020. They were changed halfway through 2021, and the most recent amendments that became effective on May 9th of this year changed them a little bit. But some of them make sense in the sense that the police department are not required to give somebody a DAT if there's some action that needs to be taken with respect to that person right then. So for instance, the most common example is if a person has an outstanding warrant at the time they're taken into police custody. The police don't have to release that person and say, we know you didn't go back to court that last time, but promise us you'll do it this time. Under those circumstances, the police can bring that person directly to court, and with respect to the new case, a live arrest is effected. If somebody has a recent history of failing to return to court, the police have the option of not issuing a DAT and effecting a live arrest. If we can't verify the identity of the person, meaning we don't know who we're releasing back into the world, the police can not issue a DAT and effect a live arrest. And then some circumstances where effectively we would be asking a court to do something, whether it's issue an order of protection, suspend somebody's driver's license, if somebody has an immediate need for medical attention or mental health care, the police can bring that person to the court for that to happen instead of releasing them without an order of protection, with their driver's license, or without some immediate need for attention that they might need. Prior to May of 2020, the police were relatively restricted by the 2020 and 2021 amendments. Virtually every e-felony, virtually every non-violent felony, and virtually every misdemeanor, except for a few domestic violence, sex crimes, cases of somebody not being wanted on some other matter, absent those sort of narrow exceptions, for the most part, the police department was required to give somebody a DAT, even if they had open cases. Since May of the most recent iteration of the most recent adjustments to DAT and bail laws, the police department has much wider latitude now. Not exactly, but close to the latitude they had prior to 2020 in terms of effecting live arrests and bringing somebody directly to court rather than issuing DATs. Once in either circumstance, whether it's a live arrest or whether it's a DAT, the district attorney's office gets involved once the police officer confirms that person's identity, prepares some paperwork that captures a little bit of what the person is accused of and what the evidence against them is, and they give that information to the DA's office. It's typically via fax or emailing scanned documents, and then an assistant sitting in the DA's office in a part of the office called the Early Case Assessment Bureau that's open from 8 o'clock in the morning till the wee hours of the morning, every day of the week, 7 days a week, 52 weeks a year. An ADA, a supervisor will screen the case and assign it to an ADA. Then the ADA speaks to most certainly the arresting officer in the case, often some other police officers, sometimes some witnesses, and makes decisions about either what charges should lie, what charges shouldn't, what investigative steps can be taken going forward. Sometimes we'll get a search warrant, or sometimes we'll ask the police department to conduct a lineup or take a statement from an individual who's in custody, or often will take a statement from an individual who's in custody. And often, or I guess a little less frequently, we'll go out to a hospital or to some other location and interview a witness in order to have, the quantum of facts we need, at least at that point, typically within about 6 to 12 hours of an incident, or at 6 to 12 hours of an arrest, in order to make some decisions about initial charges and initial, or what ultimately will be our bail recommendation or our custody recommendation when somebody's arraigned. Those in the ECAB is where we recognize that it's very preliminary in the case, so we're not going to have all the information that we would have at a point where we make a decision to indict or not to indict, or a decision about a sentence, or a decision about a plea, but it's where that sort of thinking begins. 3 burdens of proof that, as we move into the legal system, I think it's helpful to keep in mind. In order for the police to effect an arrest, they have to have probable cause to believe that somebody committed a crime. And as a general matter, it's a little more complex than this, but that means, did a particular person more than likely commit a crime? Is somebody probably guilty of that crime? And there are some pretty basic ways to get there. A person who witnessed a crime, who says that person just did X, Y, and Z. If X, Y, and Z makes out a violation of or a felony, that would give the arresting officer a probable cause to effect that arrest. And there are multiple ways to do that, with video evidence, with geolocation information. Like there are many ways to get there. I would say the most common is especially for live arrests, is generally a witness seeing some behavior or video capturing some behavior, and the police identifying the person either on video or who engaged in that. For a grand jury to vote an indictment, I'll get into the grand jury immediately after this. Their burden is reasonable cause and legally sufficient evidence. It's a very similar standard, but distinct in the sense that reasonable cause is close to probable cause. It means, is a person more likely than not guilty? And legally sufficient evidence is a legal standard that the grand jury has to find, and ultimately judges will review to make sure that there is sufficient evidence of each element of each crime. So by way of example, I told you that the 2 elements of assault in the 3rd degree are intending to cause physical injury and in fact causing physical injury. And I would say the always present element of any criminal case is that the person who was arrested is the person who committed the crime. We call that identification. So in the grand jury, there has to be reasonable cause to believe that a person committed a crime, and legally sufficient evidence for those 3 elements. And it changes depending on what the elements of crime are. ultimately for a trial jury, what you think of in Law and Order, 12 citizens, many of you have undoubtedly served either grand jury or trial jury duty. 12 citizens who sit in a jury box. They hear witnesses, they hear opening arguments, they hear closing arguments, they view the evidence and ultimately return a verdict. The burden for a jury in order to find somebody guilty is proof beyond a reasonable doubt. And I highlighted that because that's also the ethical standard that governs prosecutors' ability to bring charges. We cannot bring charges against somebody if we think they are probably guilty, but we cannot prove the case beyond a reasonable doubt. We cannot indict a case if we think there's a reasonable cause to believe that somebody's guilty, but we know we can't prove the case beyond a reasonable doubt. So beyond a reasonable doubt is really the touchstone that ethically guides the decision-making of prosecutors as they evaluate cases and decide what can be brought, what should be brought, and in circumstances where we charge somebody, what charges should be brought against that person. At a person's criminal court arraignment, that's where they go. So in ECAB, police bring their paperwork, ADA takes the steps I described, and then ultimately either decides not to charge somebody or decides to charge somebody with a certain crime. After that point, whether it's the day they show up on their DAT, the desk appearance, we call it a return date, when they have to return to court, or with a live arrest when they're produced into the courtroom, generally within about 24 hours of their arrest. And they're brought before a judge. Same thing with DATs. Once you return, you're brought before a judge, and there are ADAs in the courtroom. The person who's accused is assigned a defense attorney. There's a judge in the courtroom and sort of generic court staff. This is the time that a defendant is informed of the charges against them and is actually given a legal document that outlines what some of the facts are, very, very generally that support the charges, or that we believe, or the police officer believes support the charges. And ultimately some notices are exchanged. There's some important timelines that begin at this point. One is a speedy trial timeline, in the sense that for violations, there's a certain amount of time you have to be brought to trial. You, as the accused, are entitled to a speedy trial by the New York State and federal constitutions. For misdemeanor crimes, that's 90 days. For felony crimes, it's 6 months from the date of arrest. And both of those clocks start the first time you see a judge. There's also some notice requirements. You have to be told about ID procedures or statements you may have made to the police. And kind of underlying a lot of the steps that we're going to go through, there is, since 2020, a necessary but burdensome discovery burden on prosecutors to produce some very important pieces of evidence to somebody who's charged with a crime, like the video, any DNA records, medical evidence, police paperwork. Some of the things that we're required to produce are much, much more mundane and a little bit further from what the actual facts are, or what the actual facts that will matter at trial are, but are nonetheless, we're required to produce those to the accused so that they can make informed decisions about who they want their lawyer to be, whether they want to go to trial, whether they want to seek a potential plea offer, whether they want to talk to us about the circumstances of that crime or other crime. The general idea of this disclosure requirement is to allow the accused person to be an informed decision maker, the same way the prosecutors who have gathered all this and done all this are. What also happens in somebody's arraignment is the people can make a request or a recommendation to the court, and the court will ultimately make a decision about that person's release status. There are a number of different ways you can leave arraignments. You can be released on your own recognizance, which means you walk out the door. You can be put on supervised release. Supervised release is a city program that's designed to help people return to court. It reminds them of their court dates, stays in touch with them. I think the mayor's office, I think the city is moving in a direction where the program provides more support to somebody between court dates. But right now, or since its inception, the mandate for the program and what it does is return people to court, not necessarily provide necessary services between arraignment and the next court date, or one court date and another. And again, arraignments, like the Early Case Assessment Bureau, is open 7 days a week, 365 days a year, opens at about 9 o'clock, and it closes anywhere from 2, 3, 4 o'clock in the morning, whenever the work that night is done. So what happens after arraignment and your path through the criminal justice system depends on whether you're charged with, on the one hand, a misdemeanor or violation, or on the other, a felony. A misdemeanor or violation, because they're lower level offenses, the law recognizes that they're lower level offenses. You can be charged by a sworn document. So it could be a police officer saying, I was standing in a store, I saw Shawn McMahon pick up a Snickers bar, walk past the cash register and go outside with it. And I was told by the store owner that he didn't have permission or authority to do that. That is a sworn legal document that is sufficient to charge me with a misdemeanor or a trespass or any lesser crime. Same thing for they're often common in domestic violence incidents where a victim of domestic violence can say, I know John Smith, he's my husband, he punched me in the face on this day and it caused me to have a split lip and pain for 4 or 5 days. For a lower level crime, or the two lower level crimes in New York State law, that's sufficient to bring charges against somebody, to actually try them on that instrument. Felonies are a little bit different. The law kind of recognizes that because it's a much more serious offense, that there should be effectively no one police officer, prosecutor, or judge should be able to charge somebody with that serious of offense. And it requires 23 citizens who are pulled for grand jury duty from Battery Park to Inwood, who sit in a room, and prosecutors come in and say, ladies and gentlemen, I would like you to consider, at the end of my presentation, I'd like you to consider 2 charges of assault in the 2nd degree and 1 charge of robbery in the 3rd degree, under the theory that we give a brief précis of what the evidence might show. And then we have to actually call witnesses and show the grand jury evidence to meet that burden of reasonable cause and legally sufficient evidence that the person that we seeking an indictment against committed that crime. So after an arrest, case goes to a complaint room. If we decline to prosecute the charges, the person goes free there. Often that could mean that we're further investigating the charges. Sometimes it means that all the available evidence indicates that the person is not culpable for a crime beyond a reasonable doubt, and that may be the end of it. If somebody is charged with a crime, they go to criminal court arraignment. They're following criminal court arraignment. If the charging document in the context of a misdemeanor or violation doesn't sufficiently make out the charges, it can be dismissed. Same thing with a felony complaint. If it survives, if it essentially a judge's initial review of that finds that it's sufficient. For misdemeanor cases, the case goes forward. Ultimately, a person will plead guilty, accept a plea offer, plead not guilty and go to trial, or ultimately the case might be dismissed down the road. For felony cases, once they survive that initial court appearance at the initial court appearance, someone will be charged with a felony by a sworn complaint from a police officer. The next step to formally charge somebody would be to bring the case before a grand jury. I'm reasonably confident that many of you have been summoned, if not served, for grand jury duty. Grand jury proceedings are secret by statute. Grand jurors, prosecutors, witnesses, I guess the only people who aren't bound by this are witnesses, but grand jurors, court staff, prosecutors are prohibited from talking about what's being investigated, what witnesses are called, what evidence is seen, who's charged, until the indictment is unsealed at somebody's Supreme Court arraignment. Grand jury has to be 23 citizens, or 23 people have to be sitting in a grand jury or make up a grand jury. A quorum is 16, meaning there have to be 16 grand jurors present for the grand jury to do anything at all. And a majority of the total number of 23 have to agree to take any formal action. And that formal action can be indicting somebody, could be sending a case to criminal court or family court. It could be dismissing all charges against somebody, which in the most circumstances is the end of a case, or in complex circumstances. And one of the most common is Michael Brown's killing in Ferguson. The grand jury can issue a report that usually comes through the prosecutor or the prosecutor's office describing an event of particular public importance. Sorry, I'm going to move quickly through a couple of the other slides because I know I've taken up my half hour and I want to get to some of your questions. Again, the burden of proof, in a grand jury is reasonable cause and legally sufficient evidence. The what's underlined here, or what I meant to underline here in the grand jury indictment and Supreme Court arraignment stage is, in that space presently since 2020, there is a tremendous burden on prosecutors to produce documents, evidence, materials to the accused that affects our ability to go forward on cases. And I don't mean to make that sound, woe is us as prosecutors, because some of it are things that some of it is things that the defense was entitled to before the law, and the law had no change whatsoever, except for maybe the timeframes. Some are things that any reasonable decision maker should know before they have to make a decision of importance about whether or not to plea, go to trial, or pursue other options when accused of serious crimes. But an element of it is very clearly, I think all parties would agree, or have to agree, that a big part of the law requires us to gather things that ultimately are time consuming and won't have great moment in a criminal case really at all, or a criminal trial really at all. Throughout all of these stages, our office has a witness aid services unit, from literally arrest to arraignment to court dates to indictment through dismissal, for people who are victims, witnesses, or impacted by crimes. That witness aid services unit is open almost as much as our early case assessment or arraignment unit is. If there's anything that you need help with, or they can help you with, call 335-9000. Sorry, I thought I had their phone number in here. And Eric and our community partnerships unit are extremely helpful for, WASU is designed to help individuals who are closely impacted by crimes. But, in order for us to be responsive to folks like you all and our community partnerships unit, and folks like Eric around the city are here to make sure that we can be responsive to your needs, concerns, questions, comments, etc. So it was a little longer than I meant to go. I promise you, each slide could probably be a 45-minute to hour-and-a-half conversation. So I'll open it up to anything you all want to hear from me or tell me.
Yeah, so thank you very much, and both to you and to Eric. Eric's been at most of the Chelsea Community News meetings and very helpful. Thank you for coming. And if people will have questions, they can raise their hands and I will call on you. I don't see any raised hands. So I am going to start off with a question. There we go. I see them. I'm going to go with Sally Greenspan first. Sally, you can unmute yourself and ask a question.
Okay, thanks, guys. That was informative and helpful. We'll ask a question a little off topic. I heard Governor Hochul interviewed on Brian Lehrer this morning, and she mentioned that in the last few months, the bail reform laws have been tweaked a bit. I was not clear on what those tweaks were. Can you fill in the blanks?
Yeah, I mean, I would tell you that they're relatively broad. Some of it is there was an existence of what we call a harm application. And I don't mean to, I'm not criticizing the bail laws. I think that a lot of it is very well intentioned. I think the original bail reform law was painted with a very, very broad brush, and there wasn't perhaps as much feedback from practitioners, whether it was prosecutors or defense attorneys, about how that would work out. So one of the shortcomings of the original bail law was, if somebody was arrested for a felony crime that was not bail eligible, so for instance, a pickpocket, if I picked your pocket and I got arrested on scene, that was not bail eligible, I could walk into court, and I would walk into court and I would be shown the door at the end of my arraignment, and the process would continue, but that was not bail eligible. Under the original laws, if I got arrested again for a second pickpocket, that first pickpocket might become bail eligible if we decided to reveal some of the evidence of the second pickpocket, but the second pickpocket was still not bail eligible. So at that point, absent a hearing on the first case with all the people involved in the first case, I still walked out the door. The 2021 adjustments to the bail law narrowed that a little bit. It kind of it recognized that in this example that if somebody commits 2 crimes and we're deciding that one is bail eligible, we should really allow judges to look at both crimes. So it sort of fixed that loophole a little bit, and it added, not loophole, it fixed that shortcoming, I would say. Another example that was fixed by the most recent ones is that created this what we call a harm exception. If somebody were out on a crime that was not bail eligible, and in that crime caused an identifiable harm to a person, and then committed either an A misdemeanor or a felony offense subsequent to that, that also caused harm to somebody. It doesn't have to be the same harm, doesn't have to be the same kind of harm, or doesn't have to be the same harm, doesn't have to be the same person. The second crime would become bail eligible. And that was just a little bit amorphous. And we started exploring, as I'm sure you all have seen in your neighborhoods, that shoplifting and property crimes is much, much more prevalent than it was a couple of years ago. What the most recent amendments did that, or one example of the most recent amendments, is it made explicit that in that harm analysis, judges can consider harm to property and harm by property loss. Another example is the standard set by the law is any amount of bail or any what we call a restricted, the order the judge issues to determine whether a person is released or not has to be the least restrictive means to require that person's presence in court. And it limited some of the things that judges could consider for that. One of the most recent amendments expressly said judges can consider somebody's recent recidivist past, and judges can expressly consider somebody's either possession or use of firearms.
Thank you for that.
Thank you. Thank you very much.
Okay, I'm going to go on to Julie and then Pam next. So Julie H.
Hi, thank you so much, Shawn. It really was very informative. And I guess one of the things that, with the recidivism issue that you mentioned, I guess that's the thing that jumps out to me most of the time, even just in some of the local crimes that we see. But do you have any suggestions or advice on how, as a community, there might be some methods that or ways that we could, help out in terms of you don't want to be reporting things that are seem petty or, things that may not, as you mentioned, once you learn more about what you just presented, you have enough, on your plate, the 10th precinct with trying to keep these larger crimes at bay than some, maybe noise complaints and the like. So, any advice? I'd be interested to hear.
I mean, I would say initially, or not initially, I think the best thing is communication, whether that's doing exactly what you're doing now, coming to these meetings, talking to our community partnerships unit or me about what the issues that your community is facing. Some of that is going to be things like natural quality of life, like this is an issue that affects my well-being that the DA's office just doesn't have the ability to impact, but where we can, we want to know what we can and can't do. Also, along the same lines, I'd say, in that the arrest to arraignment or arrest to sentence context, often what we hear is third hand. We'll talk to witnesses who experienced the firsthand incident, but we don't really know the context of that behavior inside of a community. So for instance, if we hear, I might get a petty larceny case tomorrow, and I'm like, oh, there's an individual who's been arrested multiple times at other locations, or a couple of different locations in this neighborhood, but he's not stealing a lot of money. He's not hurting anybody. It doesn't seem like that serious of an offense. That to somebody like you in the community, you might be able to say, no, that person is outside that Duane Reade every day, being intimidating. He makes people uncomfortable. There may be people who work at that Duane Reade that can add to that and say, this person doesn't expressly threaten me and really isn't committing a crime, but here's some context to what's happening that really should, and we want to influence the way we approach those problems. So I would say communication is the best way to do that, whether it's with your local police department, with this group, with our community partnerships unit. There's a unit in our office that I used to run, the crime strategies unit, that is charged in large part with putting individual incidents or patterns of incidents in the context of how it's impacting a community. So I would say keep doing what you're doing and telling us what are issues, talking to each other and talking to your local precinct.
That's very helpful. Thank you. I'm going to go to Pam next. Pam, would you like to unmute yourself? Try to make your questions
did it.
short.
I've done it.
Okay.
Yeah, I'll try to do this as concisely as possible. This will be a hypothetical, and you may have already answered this and it just went over the top of my head. I'm not sure. But we have had a number of breaking and entering involving some theft, I think, recently in our area. And the recidivism issue seems to me that those crimes that this person is already, everybody knows he's done that and it's been recorded. When he does it again, he or she, and although it's a breaking and entering, there's no theft involved necessarily. Do the prior arrests have weight toward keeping him from getting back out on the street right away? Sorry, I'm poor at wording this, but that's my question. Thanks.
No, it's perfectly worded. Sorry, I laughed when you said hypothetical, because prosecutors' offices notoriously give their applicants hypothetical questions that are really, really difficult to answer, and I haven't been in that position in a while. So the answer to your question is yes, but it depends, in the sense that if I did just give you an example, if somebody has stolen from a Dwayne Reed 5 times out of 7 days, and on the 6th time they walk in there and they go directly back to the same aisle that they stole all those things from, the first 5 incidents give context to what was probably going to happen on that 3rd time. There's a legal standard, or that 6th time, there's a legal standard, it's called Molyneux evidence, where we can, as a general matter, if you're charged with a crime, we, the prosecution, are limited to the evidence of your conduct with respect to that crime. And the jury and the grand jury never hear about your criminal record or other incidents, because fairly, if they're deciding whether or not you committed this, they shouldn't know that you're a serial burglar or you have a history of doing this. Molyneux is kind of an exception to that, in the sense that it allows the jury to know, whether it's a grand jury or trial jury, to know this person has been to this Dwayne Reed multiple times before, this apartment building multiple times before, and they've engaged in this behavior multiple times. I'd say, so that's the legal context and how that happens. The practical context is, in the grand jury, we as prosecutors have to make a decision consistent with what we're kind of the judges of the law. We have to make a decision about how much of that we can show to a jury that is fair. Otherwise, the judge who reviews the indictment down the road might say, no, Shawn, you showed too much of Ms. Wolf's prior history, such that wasn't fair. The grand jury might have convicted or indicted her based on the elements of her criminal history you presented and not the crime. So it's kind of a balancing act. And I would add to the end of that just an asterisk that all of our decisions have to be evidence-based. So it depends on what the evidence actually shows. If the police department does a tremendous job of investigating pattern burglary incidents, where whether with respect to close in time geography or close in time spatial relationships, they believe that somebody might be targeting the same location or close locations. But unfortunately, a lot of burglaries, if there isn't video evidence or if there isn't a witness, what we have is forensic evidence that might be left at the scene, sometimes a modus operandus or what a person's sort of MO is. I guess it's the same thing. And there has to be, in order for us to ever get into what somebody's prior acts were, there has to be a quantum of evidence that satisfy us that it's relevant to this act, because it shows their intent, that it was the same person, that it's a pattern of behavior. So it's kind of 2 steps in that sense.
Wow. Okay.
Thank you.
I'm innocent, I promise.
Thank you very much. I'm going to go to Mark De Sola Price. I hope I didn't terribly butcher your name. Go ahead and unmute yourself.
Mark DeSala Price, got it perfect. I was really impressed in the presentation on how densely the whole process worked together. It was kind of like hearing how an internal combustion engine works, and there were all these parts. And as fascinating as that was, I was a little disappointed because I was hoping that I would have an idea of, well, and there's this part for the district attorney, and this part for the judge, and this part for the police, and that I could see, oh, what I'm seeing is, if you tweak this one player, it will be different. And I have absolutely no idea whether, any of those parties are doing exactly the right thing, or, if in Philadelphia or LA or Chicago, the parts are a little different and have different results. How can anyone in the community like us help affect change when the system is so complex and we really can't have a good idea of, we might know what sort of results we want, but not a process of how to work towards change?
But I'll steal a phrase from you. I think you put it perfectly. It certainly is complex and interconnected. It's like a combustion engine in the sense that one part moves another part. That second part both moves a third part and is moved by the first part. So the actions that an individual takes impact what the police department knows and what steps they can take. What steps they can take and what they ultimately find out impacts the decisions that ADAs can make in ECAB and initial charging decisions. What we can know and what we charge impacts what judges decide going forward at arraignments. What judges decide at arraignments and what happens in ECAB, it impacts what decisions and what evidence can be sought going forward to either make a case stronger or pursue a case that we didn't think we could beforehand, or ultimately dismiss a case because the evidence that we initially thought was there was of a different quality or wasn't as much. So I think you sort of hit the nail on the head in the sense that the interconnectedness of it is incredibly, incredibly complex. I mean, in terms of figuring out how to change it and make it better, I would say that civic attention to it is the most important thing. Exactly these types of meetings, talking to your police department, knowing what they know about the neighborhood you live in and the neighborhoods that you're concerned about, coming to these meetings and talking to our community partnerships unit. I mean, when I went to my last, I was a line prosecutor for many years. I handled cases in front of me. I thought I was pretty good at it. And I enjoyed getting to, and I was challenged by the idea of getting to what is the right thing in this circumstance for the accused, for the person, if we get to the point that this person is guilty and we've proven that they've done something bad, what's the right thing for the community that experienced this? What's the right thing for the individual that experienced this? And when I went to the crime strategies unit, now my current position, I'm encouraged and challenged by community groups, defense organizations, community-based organizations, other elected officials, community councils that are all sort of pursuing that, what's the right thing and how do we get there in each circumstance and more broadly. So I would say I don't have a definite answer of how to fix something other than I think this engagement is the first necessary step to get there.
Thank you. Thank you. We have a number of questions, so I'm going to go in the order that the hands are raised. Brian S., if you could make it short. I want to get in at least 3 more questions.
Yeah, sure. So my question is, we've heard a lot from the DA's office around wanting data to guide the decision. So we didn't have much data in your presentation, but would love to understand what are the trends we're seeing in terms of arrests to either conviction and pleas in between. Are we seeing more pleas, and what are some of the drivers of either the trend, I guess the general trends that we've seen in the past few years, and is it changing, or I kind of just want to know what's the data and where is it trending?
Good. I would tell you that the first problem is, COVID. The last 2 years have sort of turned everybody's tracking of everything a little bit on its head. The Manhattan DA's office has a couple of public dashboards that show what charges are, what phases cases are being disposed of or dismissed, what the resolutions are. I don't have it handy, but at the end of this, I'll send it to Scott and I'll make sure that it can be distributed to all of you. I mean, to your point about what direction are things going in, part of the problem is, we had at least 2020 was sort of a stop and start of procedures, and court was always open, and we were always pursuing charges against people that we thought we should. There were different points that grand juries were open and weren't. There were points in time where it was very difficult to ultimately get to a criminal trial with, a pettit jury with 12 in a felony case with 12 jurors in a single courtroom that has to be constitutionally open to the public. There were points where we expanded that and points that it got limited because of COVID. I would say we're not quite at capacity yet, but we've taken care of a lot of the backlog that we built up, that the multiple moving pieces of the justice system built up over the past 2 years, and we're getting pretty close to capacity. So I'll make sure that I share that dashboard with you, and I would say that we're moving in the right direction. I just don't know that with respect to pleas, charges, or trials or sentences, that the data from the past 2 years is really indicative of what's been going on inside of the criminal justice system in terms of fact finding and getting to the right resolution.
Thank you. So I'm going to squeeze this in here again. Scott's email, scott@chelseacommunitynews.com. For any of you that have any questions afterwards, you did register, so most of it will be sent to you. I'm going to go to Joe Mafia next. Joe Mafia, please make it quick so I can get into my questions. Thank you.
All right, thank you. Shawn, I appreciate the presentation. If possible, can you share the slides? I thought the flow chart was really helpful to understand. Can you talk about the timeline from the point of the crime to arraignment? How much time are we really talking about? And focus on, it wasn't clear on the presentation, at what points are people being released back?
Sure,
Is it
absolutely.
at arraignment? Okay, thank you.
So for a live arrest, the point from police officer putting handcuffs on somebody to being before a judge and being informed of the charges against you is generally less than 24 hours. New York City and Manhattan especially have a very good track record for keeping that under 24 hours. For purposes of live arrest, that's the first point that somebody might be released. Whether we make a bail argument or whether we think that, or we tell a judge that somebody either should be released on their own recognizance, somebody should be released on supervised release or electronic monitoring. That's the first point that somebody can be, they're effectively in the custody of the person who arrested them from the arrest until that point. For desk appearance tickets, somebody goes to the precinct, they're arrested, their identity is confirmed, and they're sent back home. And about 20 days later, they have to show up for their arraignment. For the most part, if you show up to your arraignment, depending on what your history of returning to court, the nature of the charges against you might be, if you show up to court, you're going to be released because you've demonstrated your ability to show up to court. But in desk appearance tickets, that first court appearance is the first time that somebody can either be held in or released back to their community. At both circumstances, whether it's a misdemeanor or a violation or a felony, if a judge sets bail at that criminal court arraignment, it starts another clock. For felonies, we call it the 180-80 clock. And for misdemeanors, we call it the 170-70 clock. And what it means is those are just two CPL sections that say for a felony, we have about 6 days to present that case to a grand jury. It's sort of the law's agreement that if you, prosecution, want me, judge, to hold somebody in custody while they are presumed innocent, you have to present some evidence to the grand jury to demonstrate that there's reason to believe that these charges might ultimately be true. And the same thing with misdemeanors and violations. The 170-70 date is effectively if there's any hearsay or if there's any statements in the charging affidavit that need to be corroborated, you have 5 days to do that, or else the person will be released back to their community. Whether or not we meet those obligations on that next date, the court could conceivably release somebody. In misdemeanor cases, actually, I should say, if we don't meet those obligations, the person is released regardless as a matter of law. There's nothing we can do to hold them in on that charge. With misdemeanors, the case goes forward, and realistically, at every court date, there could be a circumstance where somebody who's out is held in, or somebody who's in is released. For felonies, somebody will be held in on their 188 date. They'll have a Supreme Court date, probably about 20 days out, give or take, where they're informed of the charges in the indictment against them, and the process sort of begins anew. As a general matter, at every court date, somebody's custody status could change.
Thank you.
Thank you. That was very, very good question and very good answer. Sean, do you mind if we go over by 5 minutes?
No, that's fine.
Okay, great. I want to get in 2 more questions and then I'm just going to have something to say at the end. I'm going to go to Scott Stifler next. Hey, go ahead, Scott.
Can you hear me?
Yes.
Yep.
Excellent. My question is, when somebody is arrested, and when exactly is there an assessment if the suspicion is there are some mental health issues involved? And at what point does that play a factor in not being incarcerated or awaiting in jail, awaiting trial? And if somebody who is known to have fairly serious mental health issues, some things that need attending to, what facilities, what kind of treatments are there at Rikers? And it's a twofold question. So that's the first part. The second part, there seems to be general agreement between the NYPD, between the DA, between judges, that Rikers is a pretty horrendous place and only the worst of the worst go there. Is that factor playing a part in the raw amount of people who are not sent to Rikers? If Rikers were a better place, would we have more people incarcerated as they await trial and not back on the street?
Oh, so you saved the most complex and multifaceted question for the overboard. Okay.
We have one more after that won't be that
Totally.
complicated.
Totally. Look, Scott, what you're addressing is what we are hearing from many community groups around, or from many citizens around the city. From a legal standpoint, there are a couple of things. The first is there's a mental health law that allows the police to take somebody who they have reason to believe have a medical or mental health need to a facility for an evaluation as soon as they come into their custody. The reality is that evaluation and the amount of time they spend in that facility isn't very long. It can be up to 72 hours. And the person generally has the right to leave if they want to. Involuntary commitment in New York State is very rare, and it's a very high standard. If you could do it for a family member, we could do it for someone under certain circumstances, but it's very, very difficult under New York State law to hold somebody in a medical facility or a mental health facility against their will. There are 2 other pieces of that. Ultimately, if somebody is charged with a crime, their mental state affects 2 legal, and then there's an equitable circumstance I'll get to. The 2 legal circumstances relate to fitness to stand trial and culpability for what they're charged with. You know, fitness to stand trial is you have a right to understand the charges against you and to contribute to your own defense. And if the court or a defense attorney, or to a certain extent, we think that somebody can't do that, we can ask the judge for what we call an Article 730 hearing. What that means is psychologists or psychiatrists will separately interview or separately evaluate somebody charged with a crime to see if they understand the process. They know who a judge is, they know who their attorney is, they understand the charges against them. If they do not, a couple of things happen. If it's a misdemeanor case, the case will be dismissed and the person is committed to the Office of Mental Health for up to 90 days. If it's a felony, the person is committed to the Office of Mental Health until they are fit. So they stay in custody. At some point, they'll be retested every once in a while and brought back at a point where they sufficiently understand the charges. And sadly, it's usually related to getting a certain amount of medication that gets them well. Then they'll come back and face those charges. The second one, the culpability context is, the murder she wrote, pleading insanity. If under New York State law, somebody has to understand and appreciate their actions in order to be found guilty. So you could plead not guilty by reason of mental infirmity. And what that means is I lacked the consequences of my actions, or I lacked the ability to control them, and therefore I shouldn't be found criminally guilty. If somebody successfully proves that they are not guilty by reason of some sort of mental infirmity, they're not really, they don't go free. They're committed to a mental health facility for a certain amount of time that's largely dictated by the mental health needs of that person. On the equitable end of that, that's something we're always thinking about. I'm sure you see in your communities, there are people who are engaging in some lower level and some more scary behaviors that very, very obviously have some sort of mental infirmity that's probably either contributing to or preventing them from inhibiting the kind of behavior they're getting into. And I think that's one of the most intractable problems between the segments of society that end up involved in the criminal justice system who we wish we could do more for. And I think a big part of what our office is doing, DA Bragg created a Pathways to Success division that is designed largely to do that. Let's solve problems for people who committed crimes that put them in a position where they are less likely to engage in that behavior again, rather than put somebody in jail for 15 or 20 or 30 days at a time. But I mean, I guess in sum, I'd say you sort of hit the nail on the head of one of the most intractable problems in the criminal justice system. And we think about it through those lenses.
I also had that follow-up question, which was, it's generally agreed upon that Rikers is a pretty horrendous place. Is that impacting in any way the fact that less people are sent there? They're simply not sent there because it's so bad, so that they come back on the street. Does that have an impact on recidivism?
Whether it has an impact on recidivism, I don't know that I can speak to. I can definitely say it does with respect to bail decisions that we make. Under the Vance administration in fall of 2020, the trial division issued an order that basically laid out what everybody could see in the news and kind of knew from talking to their defense attorneys and sometimes witnesses and victims who were incarcerated, that Rikers is in a really bad state. And we recognize that there are circumstances when that really bad state is necessary, but where it's not, we're making sure that we're considering the place we're sending to somebody when they've stolen a small amount of items, or they have a record for stealing not a tremendous amount of value or items, and the amount of harm they're causing is a little bit inconsistent with sending them to that place. Also, related to your other question, considering what the needs of that person might be and how sending them to Rikers or not sending them to Rikers would be serving those needs.
Thank you. Okay, so thank you very much. I'm going to give us 2 minutes. Mike Nobile, you have 60 seconds. So give us a 30-second question and Shawn can answer in 30 seconds.
Yeah, sorry,
Thanks.
I've probably been the most long-winded of everyone.
Start the clocking. Yeah.
Okay.
Shawn, thanks for the presentation. Let me tell you that I used to be a defense attorney way back. And what I see now is entirely different from the way it was 40 or 50 years ago. And, perceptions matter, I guess, to the public as well as to someone like myself. And when I see something like the fellow who punched someone up in the Bronx, who was on lifetime parole, getting released, right? And having the governor come in and, tell the parole department, I guess, to go and get this guy on a parole violation. How did you folks in Manhattan, see that? I mean, how did you react to it? Could that have happened in Manhattan?
Well, I would tell you two things. One, in that context, we have very limited control over what parole does, whether it's Manhattan DA's office in Manhattan or the Bronx DA's office. Like, we're largely focused on the crime before us and how to prevent crafting a resolution that prevents something like that from happening again. But it's a balancing act. We have to consider what the harm was in that circumstance and be aware of it in our cases going forward. But you don't want to be overreactive and say, well, I don't know if this person is going to go out and punch somebody in the face, so I'm going to be overly punitive here. Or I don't know if this person is going to be, on the front page of the Post, so I'm going to err towards the side of being more punitive. Finding that balance and being aware of those instances, as well as being aware of instances where, I guess risk management is the best way to think of it. ADAs and ADA supervisors, and especially our Pathways Division, are very, very good and getting better and better every day at risk management in terms of setting people up for succeeding following involvement in the criminal justice system and avoiding, the worst risks and the worst outcomes.
Well, it was pretty
Thank
clear
you.
from what we saw that this fellow did this in plain view. And there should have been enough to hold him on that alone. The DA, on the other hand, said, no, we've got to gather more evidence. That, to me, even with my own, biases and all that business, that to me was just too much. It was just too much. I'm just airing my.
Thank
my
you, Mike.
thoughts.
Thanks.
Okay, see ya.
All right, I just want to, we have one more question, but I want to say thank you before everyone starts leaving. Thank you very much, Shawn McMahon, Eric Straza, and Chelsea Community News for bringing this special edition. And the last question will come from me. It's more of a statement than a question, but when you were talking earlier, you said we need to, the mayor or the city needs to provide more support between arraignment and court date for people who need help going back, if they have a desk ticket, or how do we, as a community, get the city or the mayor to give more support to people who need help? It might stop crimes in between, or it might stop them from going to a crime and never showing up in court again. Is there anything we can do?
I don't want to beat this answer to death, but the answer to me is the civic engagement that
Okay.
you're already
Thank
demonstrating.
you.
I mean, our office, the police department, the mayor's office, and other actors in the space are trying to connect folks needing services with those services as early in this process as possible. So this is being worked on in a lot of different places and a lot of different offices and actors in the criminal justice system.
That's perfect. That's good to know. So everyone out there, I know you're all civically engaged, but get more people out there and tell your friends. Thank you, Shawn. Thank you, Eric. If anyone has any questions, email scott@chelseanews.com and we will send something out about this with a recording, which will be available to everyone. And we can always reach out to Eric, who is assigned to us, and we'll bring everything to the DA's office. So thank you. Thank you both. Thank you everyone for coming. Have a nice rest of the summer.
Thank you for having me.
I appreciate your time. Bye-bye.